All right, let's see, 4:06. Let's call this meeting to order for the advisory subcommittee and hand it over to Mr. Hunter.
All right. You guys should have got all these items. We're live streaming, by the way, and we're going to talk about the in-family conveyance process slightly. Once at your seat, I emailed all of you all this stuff, but we'll go through it pretty quick. And as I mentioned in the email, most of this you have seen. So just to give you a quick history, we sent a text amendment to the county in December that was fairly lengthy. It involved all the rural different A1, A2, RR, etc. Sent to the county, they rejected the text amendment, and then they decided to give us a directive on what they'd like to see in substitute of the in-family verbiage that we sent out. So page 2 of your document here is the directive, and what they did, they met several times. Once they rejected our proposal, I didn't participate with fiscal court at all in any of this. They sort of got to this point on their own without any of the planning commission staff involvement. And they voted 6-2. You see page 7-2. We're in the agricultural chapter. When you get 7-2, everything you see here we've already talked about. This was in our proposal we sent to the county. They had no issues with anything in our, honestly, what we heard is they didn't have too many issues with any of the things we sent them in the text amendment, except for the in-family paragraph we sent them. We just missed the mark on that, it appeared. So, not going to take that, not be offended by that. I kind of think they've sent us a directive. I think we just flow through it and hopefully send them back what they were asking for. But everything else you see on page 7-1, 7-2, we've already talked about. When you get to 7-4, we've plugged in the conditional use threshold stuff. And it's real simple in nature. On 7-4, we have this list of conditional uses that were already in the draft. Most of these things we already kind of allow. We just kind of renumbered them. But number N gets added, and it says in-family conveyance lots, less than 30 acres, see special provision, and then you jump the page. But this is a big deal right here. This means you would have to go before the Board of Adjustments first, and they'd be reviewing it for kind of non-platting issues. Their charge is to look at health, welfare, safety, infrastructure. So funny enough, this isn't a bad idea. The court came up with this on their own. The Board of Adjustments is charged with looking at things a little different than you all are. So they could probably take a harder look at each one on a one-on-one basis and say, well, is the water good or is the road good? Yeah. In addition, it would be a public hearing and the neighbors could battle it out on every single one. So everyone becomes its own unique situation. It does add more time and more cost to everybody, but that's what they asked us to explore. So I put it in there, but their vote 6-2 was to add the things they wanted in that directive, but the other vote was explore this as an option.
And it was what?
7-1. So I put it in here. So the first thing is for you all to think about, do you think that's makes any sense to make that a conditional use permit? It'd be 2 hops. to get to your plat approved then.
Because what is it currently, I mean, I see where it used to be.
Currently, it's a special provision, and you file a plat, you go to TRC, and you come to you all every month as you guys see plats. It's more an administrative process. It's $395. You hire a surveyor. Takes about 2 weeks to a month. This would add another $350. It's a separate hearing, but it's a public hearing. So the Board of Adjustment has hearings very similar to y'all having zone change hearings. They're a hearing board, so it'd be a public hearing on every single one. But they do them on other things. It's not like they don't know how to do conditional use permit hearings. And it does kind of bring an interesting option in that they're, you know, in a particular one, if the neighbors had an issue, they can go battle it out at the Board of Adjustments. And then when the plat comes to you, it is more administrative, hopefully, in nature.
I like that.
You like that?
I do.
Yeah. I see pros and cons, but it's really, it's a second directive that came from them.
Well, you know, one of our big concerns is the water and the roadways and that type thing, and that's what they're charged with, is looking at all that, so I think that's good.
It's your all's call, yeah. So if you think that's good, when you turn to the page, Chris is ahead of us here, and the next page, 7576, you guys have looked at all this, it's housekeeping in the chapter. When you get to 78 is now where the in-family conveyance is. It used to have our old paragraph in it, our revised paragraph. It's now got, we had to lead in with a little section that's not on theirs because we had to basically talk about a date that we evaluate these by. We also put in that lead-in paragraph, it says here, the minimum lot area for A1 district may be reduced by less than 30 only after obtaining the conditional use permit. So it ties those together, and then the 1 through 8 matches their list. Their list is 1 through 7 because one of their paragraphs is a little wordy, and we broke it out into 2 paragraphs. I think numbers 3 and 4 got split from theirs to sort of make it a little clearer. But if we want to go down through them, this is their directive. And we had the wordsmith a little different than theirs. You might tear theirs out, or if you guys want to look at them side by side or pull that page off. The first one basically says there has to be a residency test to apply. So you have to prove you're a Woodford County resident before you can make application for an in-family. They're keeping the word in-family. We call them exception lots. They're keeping the word in-family in number 1. So number 1 pretty much just says you got to create proof. Somehow, if you go back again, you might want to look at theirs. This is where it gets a little tricky. Their directive said applicant must be a Woodford County resident. End of sentence. Well, we're the ones that would have to take the application, so we had to wordsmith this slightly, and it says that in-family and Cambridge plat shall be required to submit proof of a Woodford County residency to create a lot. Applicant residency location shall be certified on the plat. I'm not sure how we handle this, but this would be something we'd have to figure out, that if you file the plat, I have to somehow figure out you're a resident here. Well, how do I do that? I tell you, come down and show me your driver's license. We do a blood test. I'm not sure what we're doing. But I think we can figure it out, and what we ended up putting here is that location is certified on the plat. So basically you're going to say you're a resident and you're signing something on the plat that certifies that. I don't know how else we could do it.
Yeah.
But we're not, in theory, their directive says they just have to be a resident to apply. That's kind of gets out of things we typically would see in applications for us. But this is where kind of a high level question comes in, or you guys think about. We could start to go, well, I'm not sure that's a great one. But this is their directive, and I'm kind of inclined to suggest to you all as your staff that I prefer to send them back what they asked for in this case, and try to keep it as close to what they asked for. If we start to deviate from them, then we're right back to, well, we asked you all for this, and you changed it to that.
So you're feeling like if they sign the plats stating that they are a resident of Woodford County, in your mind, that's good enough?
I'm not sure. So we'd have to really think about what is residency. So I guess in theory,
It can't be property owner necessarily, because you can live in Illinois and be a property owner. So they said resident,
and I put in here, shall be submit proof of Woodford County residency.
Yeah.
So how would you do that? I guess you could show us a driver's license. I guess when you file the application, you could sign.
Voter registration.
We might put a checkbox on there that I am a resident, and you sign the application. I don't know. I mean, it's just not something we check, y'all.
So what if they've owned a farm for 50 years, but they've never built a house on it? They farmed it.
You're not a resident, I guess I would think being a resident, your proof of residency is you telling me where you live, basically, right? Where do I go to sleep every night?
But they could live in Woodford County, but the farm would not have been the property they'd lived on. But they would still be a resident, and it
They'd
was
be
still their
eligible.
property, they'd be eligible.
Yeah.
Okay.
But if you were,
But what if I live across the Jessamine County line?
then you wouldn't be a resident of Woodford
And
County.
unless you'd have to petition for it or something in some way, I guess, but.
So this gets down and kind of, this is something they wanted and they talked about. There's another one that gets very similar to this, we're gonna show you in a second. This is what they wanted.
Was this a committee, a fiscal court, or the whole court?
The whole court decided that.
Well, then, yeah.
So they rejected ours, they put together a directive to you all.
I do like theirs. It has a lot of checks and balances in it.
There you
It
go.
does. I mean,
And if it's a problem, I guess it's something we'll have to figure out. And if it's something we can't figure out, maybe it's gotta be tweaked someday, but this is what they asked us to consider. So that one sentence just got a little broader when I sort of messed with it, because I just wanted to put the thing that we could tie it into the plat, but there's this thing that needs to, before we process the application in theory, we're gonna have to verify they're a resident somehow.
residency, yeah.
And it may be just as simple, hey, where do you live?
So, even if it is an in-family conveyance, are we muddying the water with an applicant must be a Woodford County resident? Because if it's an in-family conveyance, that conveyance of that piece of property to that family member cannot get outside of these other 6 directives anyway.
I know, but this is what they came up with. And it is a little confusing to me. At the time you apply for a plat, for example, if you were conveying to Ashley, you're the owner, it's your property, and you're cutting it. It's not being deeded to her till some point. So you're the one I've got to check your residency
Right.
issue
Yeah.
on. Who you're conveying to, that's not what we're saying. That comes into play later though. But this whole idea of who's a resident and where they live, this is just, this would be like a pre-application situation. We just have to figure it out.
And they still have to be in family.
And well,
Yeah, I mean,
and
that-
we gotta figure that out too.
That's,
Yeah.
that was an interesting one as well.
Yeah, that's gonna change
Six on there,
too.
yeah.
So that's their first one. So that's our one versus their number one. So interesting enough. Number 2, there has to be an agricultural use affidavit submitted. We do that now for building permits. That's not a heavy lift for us. And that's what they had in their number 2. We made it almost verbatim, exactly the same. So what that's saying is whoever files their in-family conveyance plat application will have to sign an ag affidavit that farming is currently occurring on the property. So the court has put together a relationship that the people that want in families, that this all works towards, we're farming and we need these other family members close because we all farm. It's not
Okay.
that we're just cutting up houses to live out there, there's a farming component, and we're in the ag chapter anyhow, if you think about it. So they added this ag affidavit section. We don't have an affidavit like that right now, we'd have to create one. That's bullet number 2. Number 3, the lots can't be less than 2 acres in size. Their number 3 is where we kind of had to do a little housekeeping there for them. We broke that into 2 separate sentences. So the lots can't be less than 2 acres in size. Our proposal allowed 1s, if you remember. They debated 5s, 1s, and they ended up with 2. So all the lots have to be at least 2 acres in size. And then number 4, we had in our proposal, remember, we had like less than 50 and over 100. They've now made it between 32 and 49. You can create 1 lot, and if you're over 50, you can do 2. Initially, they talked about making 30 to 49, but then they were like, well, if it's required to have a 2-acre minimum, you got to start with 32 to end up with 30. Or they always have a 30-acre legal parcel. And that's what number 3 is saying too. It says may never be reduced below 30. So we wordsmith that a little tighter here. So 3 says no more than 2 acres in size. Then 4 says you get 1 for 32 to 49, 2 for 50 greater. And then we say the remaining parcel for an in-family shall be a minimum 30 acres. And then we added that last sentence that we had in our draft. If there's a remainder that's less than 30, it can be added to another parcel. That's an option. I don't think they understood that that's a...
30 is the minimum.
30 is the minimum. There says that, but you could have someone come in and have a remnant piece of 18 acres, and you could then, we're saying you could still add that to another farm if you chose to. that's an option. So if you started with 40 and you cut your 2, you know, and you wanted to leave 30, you could actually plat that other 10 to a neighbor.
But individuals that already own what we would consider to be, I guess, non-conforming below that 30 acres.
No options.
They cannot do,
But as of right now,
They can do them now.
they can do them now.
But
See,
if this is
I don't
passed-
think we take that right away from those individuals,
The court has made that decision. That's their
but we don't.
Well, and we did in our draft too. Our draft was to get away from
I wasn't here for that, or the vote on this. Meetings were changed, I was out of town.
You're on the advisory, you met when the advisory group looked at it at a glance, but here's the thing. The old rule is if you're 15 and up, you can do them now. You know, there's a stair step thing. Our draft was to take it to, was 50 and above, 50 and above. They've rolled it back to 32, but the whole issue is with the under 30s, those are non-conforming tracks right now. And the idea that you can take a non-conforming track and somehow divide it further, that's some of the arguments we had come in our hearings and discussions. How is it possible that you can create more non-conforming tracks or more non-conforming lot when state law runs afoul of that? So what the court's saying is, and our draft said, when you do an in-family, the remainder has to be a legal track every time. So there's really no way to have those bottom tier ones because they're non-conforming to start with.
I guess my question is, if somebody bought a 20 acre, 28 acre, 30, if somebody bought a 30 acre tract
They could do 2 right now.
today,
They could do 2.
yeah, but then they did not plan to do that. They've got 2 young children. They did not plan to do that until whenever.
The law's changing. They need to get on the stick and get them done now then. They can do them now.
Yeah, but I guess at my point, do we punish those people because they bought that with the intentions of doing that? And I understand what you're saying as well. But at what point do we give a grace period to those individuals if this passes prior to?
I mean, that's the
because
court's
it could
call.
be something that they did not know about, or they're not involved in this decision for whatever reason.
Well,
I just don't think we punish those individuals if they've bought this with the intention of doing that for their children.
Yeah, I think to your point, the court could enact this if they do it at all. I don't know. They could put an effective date further out into the future than it passes today. Our draft was to start them at 50 and deal with the smaller ones. And the law's changing. So like anything else, like when we used to have a 5 acre and went to 30, the rules changed and consequences are consequences when they happen. But this isn't going to happen very fast. We're talking about us taking a little bit of time on this. We'll talk about that in a second. And then the court obviously took 4 months to get to the directive. So, if someone's out there and wants to do under the old way, there is a window to do that, I guess.
I think that's why we're having an influx right now, is because people are aware that the law is going to change.
Yeah.
Yeah.
And I think that's why we're having such an influx now.
But the 15 and less, I guess it's out there. I mean, there's a lot of different ways to sort of argue that. And, I'm not very good one to do it. But if you had a 15 acre tract right now, Chris, and you're eligible to do 2, you get right back to, are you even farming? Is there a farming?
well, that's what I was gonna
connection out
ask, do you
there?
need to rezone it and can you rezone at that point, or is
You
it?
could zone RR if you can make those splits. We did a 15 acre one like that, where you leave so much residual. But the whole argument, I think we've heard through this whole process, is that the 30 acre minimum should be intact. These are ag tracts. This is an exception to the ag rule. This is a 30 acre district. And there's a farming component in all of this. So if you got a 15 acre tract out there, you might be farming and you're wanting to convey to and you're going to take the 15 down, you're going to keep 10, your kid's going to take 5. Is there still really a farming component, or are you just building 2 residential lots?
Yeah.
Building 2 residential.
Yeah.
Well, I think what the court has told us, there's the whole big dynamic is there's a farming aspect that's entrenched in their directive, and it flows in this chapter, which is an ag chapter.
And still,
I see what you're saying.
yeah, I mean,
Yeah.
I don't know, and again, I go back to, I want 30 acres because that's what I've grown up. I've always wanted 30 acres. I know this is just a scenario. And then I have 2 children and I want to pass that on. Hopefully they come back to me. I may never have farmed at 30 acres.
Yeah.
But I know
Well,
That's
they went back to the intent statement of when the in-family started, and I think we've heard that through different evidence presented to court in our meeting, that this started with a farming component, and that's why the exception was built, and that's what they see it as. It's not just a way to create small residential lots. And I mean, again, I'm just following what I heard them say. I didn't go to the meetings, I watched them on TV, and I know what was in our hearings, so, that's why they put 32. I mean, I would have thought they would have made it 30 to 49, but they did 32 because they said, well, and again, their first proposal was the minimum lot that you could convey would be 5 acres. And then one magistrate or two wanted it to be 1 acre, and then they ended up compromise on 2. So I don't know.
The only thing I would ask there on 3 is that we give some kind of grace period. I know there's been individuals be caught on things like that before, and it's.
So what kind of grace period would you suggest?
I would say at least 6 months to a year.
I mean, they could push an effective date into this anything they want. I mean, they could, if they, look, this has to get through you all, go to the planning commission, go back to them. They'll
Yeah.
probably debate it, and then if they ever get to ratifying an ordinance, it could be a year. I mean, it took 4 months just to get here, and we spent a lot more. To be fair, we spent
Yeah.
a couple years to get to them. So yeah, it's been a while.
And that only applies to the individuals that have bought prior to that change. I don't think it.
That's because the minimum was 30 acres in the A1 zone.
Yes, but from my understanding, if you own a non-conforming, you can still do an in-family conveyance.
That's right.
Even if it's 18 acres, you can still do 2 in-family conveyances. Is that correct?
Yeah, you could
Right.
15 to 30.
Right now.
Yes.
Can you not go back and make it January 1st, 2025 map?
Well, that's what we have to put an effective date on when the farm's evaluated, because right now it's based on a 35-year-old date. So what we're saying is January 1, 25, what was the farm's shape? That's how we determine the first part of the eligibility. When the law goes into effect would be a second part where the effective date is January 1, 2027 if they wanted. But we have to have an effective date to evaluate the farm, because if we push it forward, someone could go ahead and take a bunch of 100-acre farms and cut them into 50s, and we're under the new rule, if you're 15 and greater, you get 2, and all of a sudden they take a 200-acre farm and cut it into a bunch of 50s, and all of a sudden they got 8. You know, so we got to put a placeholder date that we evaluate everything from. An effective date would be something different. So, I mean, that's up to you all on that. We just put in what they said, and I didn't think more about that. That may be something we'll bring up in the
My
hearing.
argument on that would be that this has been an ongoing thing for so long, and it's been such a noise in the community. I think probably the fact that we've had all the influx of in-family conveyances shows that the public is aware that the law is going to change. So I would say the effective date is the effective date.
Yeah.
That would be my vote.
Yeah, and we're not putting that in our document, because we're just sending a recommendation that they'll ratify into the law with an effective date if they choose to.
Because it still could be another 6-8 months before the fiscal court would ever vote on it. And at that point, you know, you've still got all this time for people to be aware of what's happening and time to get in here and get that done.
Yeah.
So I think that's plenty of grace.
So that gets us through 4 and their 3. And then number 5, their number 4 says 2 acres, but then they said platted with legal frontage, touching they platted right away. What we had in our prior version is now in 5. I think gets to, they left maybe a word or 2 out. They talk about everything that has to have legal frontage. I think we all know what that means.
Yeah.
But to make it simple in 5, we just say you're required to meet all district dimensional standards. So it's more than frontage. It's frontage, width, setbacks, and coverage. So 5 is just a catch-all, says basically you got to follow all the rules of the zone.
Okay.
Pretty straightforward.
Yeah.
Their number 5 is where it gets kind of nutty on their list a little bit. If you guys think this is nutty, but I think this is actually a pretty interesting approach. they, as you know, our rule was simple, just X number, you got this size, you get this many, this size, you get this, that's all it said. They've got these other kind of catch-all things. So number 5 now is a time limit, where the property that's conveyed to has to be held for 10 years, and the property it came from has to stay in the same ownership and configuration for 10 years. The only exception would be what they say is forced judicial sale, death, foreclosure, etc. So in 6, we pretty much, again, left that almost the same, I think verbatim. So basically it's a 10-year hold on both the property conveyed and the parent tract. They kicked around 15 years. At one point I heard the word 20 years. The rule right now, the piece you convey is held 5, the parent tract's not held at all.
So now they're both 10.
Now they're proposing 10 and 10.
Death is considered a judicial action.
If it goes into the state and the court says this has to be, so that's what, so they had two attorneys in the meeting, and they debated what that all meant, and when the exceptions would kick in, foreclosures, court, I think the court says we got to do something with this property.
Okay.
That trumps any kind of holds on the plat. So they said death, which I guess they mean if there's an estate and it has to be
Yeah.
split up, then I guess that if the 10 years isn't met, a court action can negate the 10-year hold. So again, they worded it just like you see it right here. And I just left out the parentheses because I don't know what all, there could be other judicial actions. I talked to our attorney. By the way, I talked to our attorney. He couldn't be here today. He said there's other judicial actions that may be more than just death or foreclosure.
Okay.
Could be bankruptcies, or could be other things that maybe require a piece of property to be sold or split.
Before the 10 years, yeah.
So what the 10 years says, if I convey to you, you can't sell it or
Right.
do anything with 10 years. Maybe a situation, even a divorce, let's say.
That's true, yeah.
Could be all kinds of things that require you to get off that property.
Yeah.
I mean, you had divorce, and guess what? I'm keeping it. You know? So I think that's an interesting situation. The main part of this is there's a 10-year hold now on both sides of the split.
So are we,
You know.
because that was what I've got some of
Yeah.
that stuff written down that you just brought up. Is that something that, so how would you take care of that? Hardship,
Well-
divorce?
Well,
Would we need
I
to-
left it with just judicial. I just ended the sentence with judicial action instead of
Judicial
putting something in
action.
parentheses. They had something in parentheses. I don't know.
Leave that up to the courts, basically. Let
I
them
guess we'll
decide what's
figure out.
the
If they pass
judicial
it, maybe they'll
action.
clarify it further, or maybe if they go with
Okay.
what we got, we'll figure it out. I think we can figure out if we get it, what a judicial action would be.
Okay.
You know, if there's a hold on, by the way, it's not gonna be ours to figure out. Once these 10-year holds go on, they're gonna be tied into the deeds, they're gonna be recorded in the
Right,
clerk's
right.
office. And if you go to buy a piece of property that's got a 10-year hold on it, or try to sell one, it's gonna be you and the clerk and you,
Exactly, yeah.
bank attorney or somebody trying to figure out
Yeah.
if you're allowed to sell this property because there's a 10-year hold on. It's going to come down to how it was worded on the plat, probably. Again, these are things that are going to be hard for us to enforce or police, which you kind of think, well, then why are we putting them in the zoning ordinance if Kim and I aren't going to be able to figure this out, nor will we be party to these things. But these are the things the court wanted in the new in-family standard.
Yeah.
So that's just something that we probably wouldn't be that involved in figuring out after the fact. It'd probably be an attorney or somebody like that.
So let me ask this. If I buy 30 acres, me and my wife buy 30 acres, I lose my job. I can't afford to pay for that property, but I have the availability to separate off 2 lots, even though it's an in-family conveyance. So I just lose my property because even though I have 30 acres, I don't have the ability to sell 2 acres or 2 lots, which would be 4 acres off of that, or the way it's written right now, 2 acres off of that. I mean, is it just
I don't know, these are,
too bad, so sad? I mean, I lose my property.
once again, I'm not sure if the old rule is going away and this is the new rule, and then I'm assuming then you've made a conveyance to be under the 10-year hold. And if you lose your job after that and you somehow, I guess you're heading towards to one of these judicial actions, which might be a foreclosure or something, but
Yeah.
but at this point, under the new rule, it's a 10-year hold on both ends of the property. I don't you know, again, we wouldn't be involved in any of these situations that would force a sale or get someone to want to sell. I mean, you would be prohibited from selling your property for 10 years, is the way they worded it. So there's been a lot of discussion about maybe those should have been different numbers. Again, I stuck it just like they sent,
Yeah.
y'all. I mean,
Yeah.
these are good questions, but,
But we still have to make changes to send back to them,
Yeah,
correct?
we have to have a public hearing.
we have to have a public
Yeah.
hearing,
Yeah.
but we don't have to.
This is
make
not final,
changes.
yeah.
Yeah. We have to bring something to the floor of the planning commission for a public hearing.
Yeah,
Once we hear the public hearing, y'all have to make a decision, but again, the difference is we got a directive from the fiscal court. A lot of times we do text amendments, we don't get a word for word directive. We're asked to, like before, we were asked to fix it. And we sent a proposal to them that was rejected. Now they've sent us a document back saying this is what we want. So again, you guys could tweak it and just say, well, we're the planning commission and maybe we think this is a better way to go. But honestly, we got a directive from the court on a contentious
Right.
matter. I would think we would stick as close to the script as we could and send it back to them and let them fine tune it based on our record. If we have a hearing and a lot of people come up and say, we hate the 10 years, we'd like it to be 20. Well, we'll just forward that all to the court then.
Can you send two to them?
I-
Two different versions?
No, I think we'd be sending one recommendation, and again, you all decide. I mean, the whole planning commission needs to weigh in this when we get to a hearing, but at this point, I mean, you see where we've evolved to. Why would we do that? You know?
And I'm fine with everything that's on here, just for me, would
Good
be
questions.
a couple of additions
Yeah.
that I personally would like to see. And again, back to what you were saying, I mean, it has been a long process. I know there's been some individuals ask questions about this, you know, what can I do? How quick do I need to do it? Things like that. And then back to hardships on your property, again, that's a sticking point for me. If I've worked my entire life to buy 30 acres and then I get to a point to where one person in the relationship loses their job and we can't afford to keep the property, that we have to sell it based on that. I mean,
but I guess that's the same as if same thing happened in the city with your house. Really, there's no difference. It's still property, right? So, I mean,
Well, we got four.
So your house, you got the right to sell it.
yeah, that's true.
exactly.
Close that.
Well, but then that's what you're saying though, is that it's a judicial action at that point. Like,
If that would fall underneath that, then yes. And again, I would, that'd be great.
I mean, surely it would have to, because if you literally can't make the payments, I mean, that's how things go into short sale, foreclosures, all that stuff, so.
Exactly. And if that falls underneath that, I would be fine with that, again, you know.
But that's a lawyer question. I don't know that kind of
So the
stuff.
last two things match theirs pretty much. Their number 6 is our number 7. Their number 7 is our number 8. They're verbatim. They're saying in the old way you could convey husband to wife, brothers, blah blah blah. They pretty much made it. It's basically parent to child or grandparent to grandchild. There's no reverse ways that
Why
works.
is that? I was just curious what the,
Well, I guess a lot of people came and testified at their place and came and said, look, a lot of people said, hey, we did it the right way. I'm just trying to give my son
Right.
a piece of land. But I think what you all know, we see them at
we
the
see a
planning
lot of
commission, we see a lot
spouse to
of
spouse, yeah.
And there was some debate whether that really occurs, but I know y'all have seen them.
Uh-huh.
And I think we know what's happening on a spouse to spouse one.
Yeah.
But the idea is if people want this to continue, and there is a farming component, and everyone's planning to just live out
Right.
there and
Right.
farm for the next, then I am going to convey to a kid or grandkid. Why would I ever be conveying to my spouse or my brother?
Hey, now I have a question.
They chose that. We didn't have that in our draft, by the way. Sorry.
Yeah.
Let's say mom and dad have been farming for years and they're tired. And they want their son to take over the farm. But the parents would still like to live on the farm. Can the parents take the small lot and the child take the remainder?
I guess, sure. Sounds like, just like we do now, there'll be a piece of land and we'll be conveying something to the child, and what the acreages are will be indifferent. As long
Just as
as,
long as it's 30.
long as the,
Well, I guess
long
if
as
it's
one, the
2,
parent tract
yeah.
stays 30, yeah. Yeah, absolutely. I think so, yeah.
Because if the original owner has to hold that 30 acres by what we're saying here,
Well, they don't have to hold the 30, they might have to hold the 5, is what she's saying. So what's gonna happen is you're gonna come in and do a
No,
conveyance.
what I'm saying is a reverse of this.
Yeah, you do a reverse.
The child gets the big piece, mom and dad get the little
Sure.
piece, so they can build a little house.
And they're both
stay
holding
there.
the 10, yeah, yeah. So when so if you come in, we start with 35 acres. And you come in and say, I got 35, I want to convey. I guess you have the option to do a 33 and a 2, right?
Yeah.
Well, who gets the 2 and who gets the 33? I think it's indifferent. Just they're both going to be held 10 years.
What if the applicant, though, who's putting in the application? At that point, it has to be the owner of the property,
They
correct?
would be the owner and
So-
they would be the residents, but then what you put on the plat would be very similar to what we do.
Okay.
Who's taking what side?
Okay.
I don't see how it'd be any different, but the challenge, to your point, is what if then they wanted to do something 8 years from now? They couldn't. You know, they're both holding it 10 years. And you know, if you got some parents that are, you know, older,
Right.
75 or 71 or something, a 10-year-old might be, you know,
Now, what if they both don't make it 10 years?
I don't know. I guess that's a judicial action.
That's a judicial
That's what I was
action,
asking
yeah.
about the death thing, if death comes in, or
I guess. I mean, if they're not there.
But I mean, hope,
what if mom and dad had to nursing home, how they gonna pay for it?
yeah,
Yeah.
I didn't write
that's a good
this.
question. That's a good question.
Asked that a minute ago. You're exactly right.
No, that's true.
That's exactly right, yeah.
You know, and by the way, these are all issues we wouldn't be involved in. The plat comes to you all, and then we record it, and then we're kind of done with it at that point.
Yeah, yeah.
A lot of the things would be hard to enforce, hard to interpret, hard to figure out, but they wouldn't be things we would traditionally be involved in. And that's what the last one's saying, that this goes on the plat, this goes in the deed, and then it carries forward that way. There could be a lot of situations, y'all, that, you know, there are liens on the property.
Right,
I mean,
right.
I don't know. So that's the whole thing. So the rest of this chapter is just striking out in the other sections everywhere the old in-family verbiage is in the ordinance. It's in 3 different sections, and then there's no other changes. So again, we're not sending them the RR stuff or the CO1, or again, just sort of keep the focus on this one section. And you all might disagree, but the original text amendment we sent was long. It involved A4, A1, A2, CO, and RR. We're
Yeah.
just sending them the A1 stuff
Okay,
to keep it simple.
now I have one more question. Let's say there was a RR piece of land that was 100 acres, and it's been farmed, literally farmed, for a period of time. Is it eligible to have a split?
No, I mean, it could be if
In
they.
no way?
No, so right now, the RR piece isn't eligible for an in-family now. You're not allowed to do them in the RR zone. The RR could be split if it, for example, it's a 1-acre zone. So if there's an RR piece out there sitting on the road that's 3 acres,
No, I'm talking like if you had a 50 or 100 acres of residual land that you built a big house on.
You can-
live there and you farmed it.
you can
and
split it.
Let's say you want to give that part to your child and you want to stay on the farm, but you just want a small little lot and a little piece of ground.
You can do that, but
Residual or
but the
rural
residual doesn't allow.
Rural residential.
Yeah, so
Residual.
the residual doesn't.
Well, no, the RR, rural residential.
Yeah, so right now, if there's something out there, the key's gonna be what's been built up to this point, because the RR is eligible for a rooftop, but the residual's not. So you can do all those splits now, but you can't build 2 houses now.
So
Can't build houses.
RR could not be divided.
It potentially could be divided, but it all comes down to what was on the original development plan. So if you came in and zoned 5 acres RR and 95 acres state residual or whatever, you might be able to subdivide that RR into 2 lots, maybe if you had frontage, or if right now it was a 5 and a 95, but you're not gonna be able to build a house on the residual. Under the old rules, you can't do it. You can still farm the residual, you can't put dwellings on it. So it comes down to how they plan that RR to function, where they planning to cut it into 3 lots or 10 lots, and they never did it. But if they did that, then the potential is no, they probably might not be able to create another
Well,
lot.
the particular property I'm thinking about, I think it's on 94 acres. And it's been farmed for many years. And the farmer's tired and he wants a little piece,
And
and he
it's-
wants his children to
Is
take
it
a
zoned
farm
residual
farm.
right now? Is it zoned?
RR.
It is zoned.
RR, not residual, RR.
Well, it should be both. If there's
Well,
RR, there should be
yeah.
some residual. Should be some residual accommodates with it if it was done that way. Just depends. We'd have to look at it, go back to the original zone change, see what was committed to, how many lots he was allowed, see where the homestead, if there was original homestead in play or not. So it's a possible, is what all we
And why
can say.
would it have been in RR rather than agriculture at that point?
There were just lots of zonings that were done. A lot of people zoned their property from A1 to A2 to RR to residual. They were just done.
And some never developed.
Some never.
Well, that's what I was
developed.
saying, what was the benefit if it's 94 and they're farming it? You know, I was just curious why it
They
was
just
zoned
never-
that way,
These people bought
while it was already there,
the
like,
residual.
They bought the
Okay.
residual.
They bought the residual,
And now they
90
think-
some acres.
okay,
And the other lots are all used up. I mean, you know, the rural residential development, all those
Got it.
lots were
Then they
sold.
probably
Yeah.
can't build a house
yeah.
there.
So then there's no way they could split off, so mom and dad can stay on the farm.
The only
and
thing would be
son
is
can take the farm
if
and
they,
farm it.
if they put more residual into play than they needed, there might be a way to come back and do another zone change and open up
A little section.
another little more RR maybe, to create a ninth lot, let's say. There might be a potential to do something like that. They'd have to probably go through a zone change procedure to do that. Yeah. But the key would be is if they didn't max out the lots, you know, if you're saying they're all built on, then probably there's not gonna be a
They're
way.
maxed out.
Yeah. They could have platted more residual than they needed. And if so, they could zone their way back out of that maybe. Possibly.
Zone their way back out.
Either go to RR or go back to A1 or something, yeah. Yeah, that'd be interesting, yeah.
But would the one lot have to be 30 acres?
It would if they went A1, yeah. But I don't know how big the farm is, yeah.
Yeah, but would that leave them enough residual?
Well, that's what we'd have to look at.
To go with the
I
RR?
don't know.
Yeah. Yeah, it's like,
If they're not, if they're A1 acres, that'd be A,
it's a
yeah.
puzzle.
Yeah, we just have to look at it. So, so that's everything right here. I said wouldn't be much. Here's the interesting
Yeah.
part though. Our next planning commission meeting's fairly light on non-public hearing items. We got one public hearing. We know it's gonna be pretty taxing. The plan was to possibly put this on the May 8th meeting, to just introduce it and then table it and just let it sit for, like we've done some text amendments, let it sit 2 or 3 months even, and see what kind, and then take comments over a couple months.
Yeah.
To get this thing rolling, if you guys are okay with it, we could wait till June to put it on the planning commission, but I can tell you we got possibly 1 or 2 zone changes coming in June. Got a lot of housekeeping things. We're just busy
Yeah.
in general.
I don't mind putting it on to tabling it.
So what I was thinking is it
For
could go
this
on to
week,
May
this
8th, and
month.
we'd actually do it as the first hearing, open it up. I just explained the advisory committee looked at it. This is the court's directive alternative for in-family.
This is non-public though, what you're talking about
This would be a
doing
public
tomorrow.
hearing.
Oh,
So this
okay.
would be a public hearing. We put it on and open the hearing and say, it's here for y'all, the other commissioners to look at, start to study up on. We're gonna table the hearing, and then if people come in June, we'll hear them. If they come in July, we'll hear them. We'll leave it open for a few months.
So we need to, when we bring this up, it needs to be explained.
Just
Instead
short.
of just laying it in front of
Just,
them and.
we do a quick explanation. This is the in-family conveyance alternatives come back from the court. We're here to give it a public hearing test. And we're ready to start that tonight, but the staff suggestion would be that we table it like we've done prior text amendments. That we table it, give you all time to study it, ask questions, and then, well, if there's people here tonight, that's great, but there's a good chance people probably didn't know, you know, we'll give them 2-3 months to come testify. And then each month, we just reopen the hearing, see if anyone wants to talk. I think we did it on one text amendment like for 3 months. And I think each month we got a couple people showed up. Then we eventually said, well,
Yeah.
I think we wore it down, and let's send it on off to I forget what text amendment that was on. That would be the plan, or if y'all want, won't put it on. We're working on our packets right now. We can move it to June, July, whatever y'all want. But we know we got another zone change coming to you in June that's gonna be, you know, interesting. I think we can stay in this room though, I think it'll fit in this room. But the May meeting's gonna be different. We're gonna be upstairs. And maybe you don't wanna put it on the same meeting. So it's whatever. But if you guys are okay with moving this draft forward, that's one decision. And the second decision, if you guys think we ought to put it on the May meeting, just to get the process out there and get it started, get the public consumption part going. Because if you guys sort of say we're good with it, it really doesn't get out to the public till we push it into the public hearing. Even for people to start reading and citizens, you know. If it goes on our agenda and on our docket, and then we table it, it's out there for people to start reading, or
Right.
hearing, or asking about.
I think there's just my thoughts, and Patty, maybe yours as well, I'm not sure. I think for me, there's a few things that I would like to clarify before we,
So clarify, you mean you'd like to see other amendments into this document, or you just?
not
You're more worried about the selling it?
the selling of the property, getting back to some of the judicial actions.
What's covered under judicial?
Yeah,
Maybe
Yeah.
Henry could help us.
Well, the problem he could, but I guess the problem is this is something they work through. I mean,
That's outside of our realm of.
yeah, I mean, there were two attorneys in here, and they wordsmithed this
They did have
down.
quite a
They
conversation.
had, they've had hours of discussions on this over 4 months, several meetings.
And it could be that the public brings that up as well, and then it has
could
to be addressed
and we need
anyway.
and it needs to be addressed, but I guess the only way to clarify it is for you to go back and talk to the county attorney or the assistant attorney or the judge and say, why'd y'all put it in there, or the sponsor of the legislation. I don't know how we can clarify that. I mean, I agree with you, the residency issue gives me a little heartburn here, how we're gonna handle that, but at the end of the day, I'm just focused on, this is what they sent us, and I'm trying, not complicate it further. That was part of the issue is, we sent them something that was a 2-paragraph, it wasn't even a paragraph, it was 2 sentences long, and it's come back to 7 bullet points. And that's fine, that's their
Yeah.
right, they're the fiscal court, they rejected what we wanted, that's part of the process, but some of these are gonna, from administrative, could be problems for us, it's honest. I'm not focused on what the rules are gonna be, because I think they're the legislative body, and they've told us this is what they want the rules to be. And our job here is to hear a public hearing, hear the comments, and make a decision on the text amendment, but, if we have questions whether these should be the rules, I don't know that this is a top-down driven
Yeah.
set of law here, as opposed to something that starts with the
Right.
staff and goes up the hill to them,
yeah.
which is what it did, and it came back. So, in the past, I'd have to go back, and I know we've gotten directives from the city on things, like, for example, when we amended the PUD out of the zoning ordinance, they said, take it out, we took it out. Good, bad, and different, we took it out.
Well, I guess, for me, then if we have no say and we have no
You do,
directive.
but you may want to do your fact finding directly with the court members, maybe.
Okay.
That's what I'm saying is, I don't know how we can clarify or try to interpret what they did. We might just make it messier, is what I'm saying.
And I think, if I'm correct, Steve, correct me if I'm wrong, Mary Ann Gill was basically the author, and
Yeah,
the
yeah,
fiscal court
yeah.
members contributed.
Yep,
and so
absolutely.
maybe a conversation with her and say,
How do you
Can
see
that
this
happen?
happening? Yeah.
Yeah,
What if farm is split? I live across the Woodford County line, and my farm lies on
Yeah.
the Woodford County side. And what if, your question about selling the property to erase the debt because you can't handle it, and see, those are things they may not have thought about, or she may say they're included in there. I don't know.
Yeah.
exactly.
Yeah. And again, the county attorney was here, and Phyllis Madeline, she's assistant county attorney, I guess, too.
Yes.
Yeah, so she was in here. They had detailed discussions about these
They had
things.
very detailed discussions.
And again, I watched them on the live stream. And so I think this is the language they ended up with. And I think our role as a planning commission now is just to give it a public hearing test like any other directive. But, if there's things you guys aren't ready to take it, that's fine. If you guys aren't ready as an advisory committee, that's fine too. This is our process. When they handed it back to us, it goes through this committee, then it goes to a public hearing when you all are ready to send it. And if there's issues y'all have, then you can work to them. But I'm saying, as far as, debating whether it should be 15 acres or 32, I mean, I don't know, they
It
sent us
came from
32.
top down at this
Hey,
point.
let me ask you this, if
That makes
we
sense.
wanted
Yeah,
to
it does.
try to clarify a couple of these issues, could one of us, and I'm not even on this committee, I just attend, have a conversation with maybe Phyllis?
Or we could ask, maybe if
Or,
they could come to our next, we could have another committee meeting and ask them to come talk to this committee.
Yeah, would you wanna do that? Or I was gonna ask if we could have a conversation and then email that out to the members of this committee and then decide, or
Yeah.
should we have another actual face-to-face?
I mean, we could, this is your all's working, this is a working committee until, you know, if you guys want, we could say, look, there's a few provisions here we're trying to get our heads around, and is there any way that maybe we could have,
Yeah, we could just,
maybe
yeah.
the sponsor, it's kind of odd, because it's the whole fiscal court took action here.
I
And
understand.
to have an individual magistrate come in, it's probably more protocol to probably have the county judge.
I think maybe Phyllis
or the
maybe
county
James
attorney
the
or
county attorney
somebody
could-
like that to come and say, here's what the
could answer
court
these
did.
questions as opposed to going directly to a magistrate.
Or the fiscal court clerk or somebody, but bringing an individual magistrate in, I think it's
Yeah.
out of the realm of them being a legislative
Right.
body, you know what I mean? So,
Could it be an email that was sent rather
That's
than,
what
yeah,
I
because
wanted
I
to
feel
ask.
like if that's the piece, like, that feels like that could be an email answer. Like, we ask the question, we get an answer.
here's where it gets tricky though. So,
And then-
so let's go back to the directive. They voted on this, right?
Right.
So let's say you all get to something and say, hey, this is a question, you send it to her and she says, yeah, that's probably right, that probably should have said something else. That's not in their directive though. So how does
Okay.
it, so they, you know, if they recognize this number 6 is a problem, let's say, yeah, that probably should have been worded different. I'm not sure they have the authority to tell you.
They wouldn't have,
This
it,
is
yeah.
what came to
It'd have
us.
to go back again anyway.
Yeah, I guess that we would almost have to say, you guys might want to try again too, but I don't think, I think.
So it sounds like the easiest course of action is to move it forward to the commission with a public hearing, get the feedback, and then,
And have it all happen in the public hearing
Yes.
form, including them come to the hearing.
and
maybe.
ask those questions
Or
in
have
front of the
them come here.
commission.
Or have them come back to the committee. You know, have them come back to the committee or have them come to the hearing and give us, you know, it'd actually be great is if we had the hearing is for them to come present what they want.
Yes,
You know, you can
That-
say, look.
that would be nice.
Um,
Can we request that? Can we
I don't
request
think
that they
I
can
don't
come to
think
the
we can
commission
request-
meeting?
I don't think we request anything of the fiscal court.
Well, I know, but
I think we could ask them.
invite,
Yeah.
invite them to attend.
Well, they sent it to us, y'all, and we've wordsmithed. I think we're really close to what they asked for, so we're not,
Yeah.
you know, right.
Oh,
very far
yeah.
out of bounds
But I
here.
would like to know what is under, you know, considered under the judicial process as far as,
Well, you know, and to that point, you might be onto something here. I mean, part of the issue was to send it back and have us kind of road test it to some degree, because we're the ones that have the hearing. So if we have the hearing, and that's the first thing you raise is, I don't understand why it says this, and that's now in our record. And now that's heading back towards them.
Okay.
Or maybe the rest of, is like, yeah, we need to
I
think
think
about
actually
that.
might be right. I think it just move it on to.
Move it into the hearing
commission
and let
the
these
public
things
hearing
come
and let it
up.
come
Yes.
to the public hearing.
Because some, like I said, it might not even come from you, it might come from one of these people sitting in the audience. They're asking the exact same questions.
The court wants us to have a public hearing on this proposal.
Yeah,
And so it may, after our public hearing, they go, wow, we missed the mark too, or maybe, because of what we heard at the planning commission meeting.
Yep.
As you know, when we did our first proposal, we only had 4 or 5 people testify over a couple months. But they had a lot more, 20-some people come speak to them in letters and stuff.
yeah.
So, so we can either work through it in this committee setting, or we can work through it to the public hearing setting.
My vote's the public.
And then at the public
Yeah.
hearing, you guys can raise all these issues
Yeah.
as planning commissioners with your counterparts, and they may have the same concerns, Chris.
Yeah, I'm fine with doing public hearing, put it on the agenda and doing that.
You're like, I'm not a voting member, so I'm just kidding.
We figured that out.
I know, right?
We figured that out. I mean, how that works. Well, it's up to y'all then, and we'll get on the agenda and do
Okay.
that. But I think, just knowing what we got next month, we'd try to, think we ought to do it first, or should we wait after the big hearing and do it second? I could see the advantage of doing it
I
first, just sort of say, here it is. if anyone's here for this, we're gonna pick it up in June.
That's true. Then the poor people waiting till
Or
the
if
very
we
end.
Get into the big hearing and we all do it a couple hours and say, okay, now we're gonna get onto this. Everyone's
No, I think this should go first.
Yeah,
That way
especially if we're
somebody
gonna-
comes specifically to that, then they can, go on next.
Yeah.
and we can.
I think
knock
that's
it
good.
out. Just do a short explanation and move it on and table it then. Would be
Yeah.
That would be the recommendation we'd have is, this was recommended from advisory committee and here's the fiscal court directive. They get the same stuff.
Okay.
And we'd recommend you table it, and then we just let this public hearing kind of move over a couple months to get good public comments and debate going. And hopefully we get a good meeting where maybe you all could discuss it in more detail.
Yeah.
Without a ton of cases on. We leave it on there all summer if you guys want.
Okay.
You know,
I think that's the answer.
does that make sense?
Yes.
I mean, you guys would have to, I guess.
Oh, do we have to like make a motion to
forward it
approve
on
to,
the
do we,
planning.
is it being approved or is it being recommended?
You're
I
just
guess?
recommending this
Okay.
go to the floor of the planning commission or to a public
Okay.
hearing, whatever you
All right,
decide.
do we have a motion to recommend this fiscal amendments and recommendations to our, what do we call this, the
Just right on
article?
first Articles 2 and 7.
Articles 2 and 7 of the zoning ordinance, to the public hearing and the commission.
I make a motion.
I'll second that motion.
Seconded. All approved? Say aye. Aye. Aye, aye.
And so then, that's it? Unless you guys have anything other?
Adjourned.